Happening now. Breaking news. Maazị Nnamdi Kanu, Ọhamadike Ndị Igbo, has once again arrived Federal High Court, Abuja, on today being 5th of November 2025 to continue his trial. Hear the news in details. All right, before I go ni rumunnem Ifab Eastern News 24. Yes, guys, we know what you bozi. Niru akwụkwọ gbasata maka ya bụ ife na-eme na obodo nọ n'ime ya and nwere ụwa na-azụ n'ala Igbo. Alright, dịka unu anụ ka o si ada Maazị Nnamdi Kanu abatagodo n'ụlọ nke ọkaikpe n'ụbọchị nke taa. Stay tuned n'iru akwụkwọ. Dịka anyị si kwuo n'ụkwa na anyị ga na-eforo the case dịka o si aga. Ọ bụrụ n'anya ikpe nke kpebu before Maazị Nnamdi Kanu si na ọ chọrọ iji aka onwe ya wee defend onwe ya n'ụlọ nke ọkaikpe, and the judge gwakwara ya si ya ngwa ya ga-eje neba anya n'ihe ndị a, cheki oge ọfụma, kpọkwa onye ọka wee malụ na criminal law. So ihe a bụ ife judge gwara ya na previous courts, that he should go and look into the case, then come up with a written address to encounter the witness and the evidence Federal High Court, Federal Government of Nigeria kwuru gbasata maka ya. And osikwa ihe mekwa na o ji wee kwuo ya, o si na all this trial niile and all this witness and evidence, none of them was committed in Nigeria. It was outside the Nigeria, which means London, and Nigeria were jurisdiction to try him in Nigeria. N'ebe ahụ try ya bụ on those places the witness mentioned. Sorokwa na ka isi ewetara nya bụ ozi n'iru akwụkwọ. Alright, also the key bia abụrụ kidnapping of him from Kenya to Nigeria bụkwa another point o ji wee jide Nigerian government iji gosi na ha enweghị ikikere try ya na Federal High Court Abuja. So ụmụnne anyị ya bụ ife ka anyị jigode wee na-efolo, and o nwere ihe anyị ga-etinyelu unu. Ihe a bụ the recap ka anyị na-akpọ ya from the previous court nke ekpere on 4th of November 2025. O nwere ihe some of the team lawyer Maazị Nnamdi Kanu kọwagasị n'iru akwụkwọ. Ọ ya amasị m dịka anyị na-eche ka ya bụ ikpe ga-esi wee gaa n'ụbọchị nke taa, ka anyị na-enegodo ya tin ọfụma, gee ya ọzọ, gekwa ya, and wee kwuo ife anyị chere n'ụdị nke anyị. Anyị ka na-echetakwa n'azụ ụmụnne m.
What is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
If you recall, Maazị Nnamdi Kanu has, to tell you that he's ready for his defense, has listed the witnesses he intends to call in this particular matter. So in the course of consulting, he discovered that the law upon which he's been charged and tried does not exist. So ordinarily, the court is expected to show more to raise this issue and ask the parties to address him on this issue, whether the law does exist.
Kanu still remains a prisoner of conscience. He's been detained unlawfully, and we are also using this medium to continually call on Mr. President to invoke Section 174 of the Constitution of the Federal Republic of Nigeria as amended, for the Attorney General to enter a nolle prosequi, at least before the determination of the court.
We remain as consultants to him, and as his brothers and braves in council.
Okay, based on today's proceedings, what did you observe and what is the way forward?
Well, my observation is that let's keep in mind that 14th October this year made it 10 years that this case has been pending. That the matter has become too complicated for the judiciary to handle underscores our core point, that this matter is more political than legal. That this is a matter for the executive branch to settle, with a political sleight of hand. It's not a matter to be offered to the limited wiggle room of a court of law of the judiciary. There is a lot of wide bat, a lot of wide space left for politicians or political leaders of this country to resolve political issues that border on agitation. Why this one has become intractable is very, very, very disappointing. There's a thesis that has become intractable because Mazi Nnamdi Kanu is an Igbo man. That thesis is becoming more and more valid by the day. So what is playing out in court now is nothing but the best evidence that this matter has gone beyond the province of judiciary and should be taken back, by the executive branch that started it anyway. There is no trial without prosecution. So it's the executive branch, the president, that triggered this through the office of the Attorney General. So the president can direct the Attorney General to take the case back to the table to see whether it should be resolved politically. But to try to resolve this case before the courts is becoming more and more impossible every day.
Is this a call for political intervention on this case?
Well, of course, everybody is calling for that. It's not throwing in the towel. What is wrong with calling with reconciliation when the courts of the land actually recognize it as well? Check out Section 17 of Federal High Court Act. It called on judges to seek reconciliation between litigants before them, including criminal cases. Section 174 of the Constitution empowered the Attorney General of the Federation to discontinue criminal prosecutions. So why should anybody say this matter should be resolved in courts when we have an alternative route of resolving it politically that appears to be easier and that would appear to be pleasing to everybody?
Okay, let's talk about the proceedings today.
The procedure today?
The proceedings today.
Okay.
What next?
I will yield to one of my.
He's saying that he doesn't have a case to answer.
As you can see the way I dressed, Mazi Nnamdi Kanu, for the purpose of this trial, is representing himself in this matter. So, and on this particular issue, we are now acting as his consultants. I'm not the only one. He has many consultants, both foreign and local, whom he consults on this particular issue, not representing him here. Now, if you recall, Mazi Nnamdi Kanu has, to tell you that he's ready for his defense, has listed the witnesses he intends to call in this particular matter. So, in the course of consulting, he discovered that the law upon which he's been charged and tried does not exist. So, ordinarily, the court is expected to show more to raise this issue and ask the parties to address him on this issue, whether the law does exist. So now Mazi Nnamdi Kanu has raised the issue and said that I cannot enter defense because in a criminal jurisprudence we have a procedure. The procedure is that for you to even assume jurisdiction, there must be a law. For the law to even exist, for you to rely on that law, the law must be an existing law. And Mazi Nnamdi Kanu now on his own filed a motion on this particular issue, telling my lord that the law upon which I'm being tried does not exist, in line with Section 36 sub 12 of the Constitution. But my lord on his own, just like what we said, my lord on his own said that section is talking about conviction. And Mazi Nnamdi Kanu said, no, you can't be talking about conviction without trial. The trial will lead to conviction. So for you to even talk about conviction, you must first of all address all those issues that will lead to conviction. So that is why we are here. It's not as if that he don't want to enter defense, but he's saying, tell me the law upon which I'm being charged and tried.
But why are we here at this stage, knowing that at a point he once pleaded not guilty, and then the witnesses from the prosecution were examined and cross-examined?
If you say that you are not taking plea, then how will you tell the judge to discharge and acquit you for no trial? Because you first of all plead guilty. Are you what I'm saying? You first of all plead guilty for court to have jurisdiction for you to even make an application. If you do not plead guilty, there is nothing before the court. So that was the issue. And he said saying that if the law, the charges upon which I pleaded guilty does not exist. This we are talking about law.
Yeah, what about the trial? There was a trial.
The defense opening their case.
The prosecution
You can raise it.
That trial.
The law said that you can raise all this issue at any stage.
Okay.
Before judgment, you can raise it at any stage, either before prosecution open his case, upon prosecution closing his case, or at any stage. So that's the stage Mazen and Dukalu is there. So on our own, so we believe that the court will first of all hear this particular motion. I hear them saying, but just like the court said, the court has every right to take decision one way or the other. Then Mazen and Dukalu still have opportunity of going on.
Well, my name is Right Honorable Obi Agocha. I represent the great people of Ikuano, Umuahia North and Umuahia South Federal Constituency of Abia State. I represent Mazi Nnamdi Kanu. From what I saw today in court, there seems to be a systemic effort being put in place to steamroll and railroad Mazi Nnamdi Kanu into putting up a defense and leading to conviction. There are procedural issues that must be heard before the matter can go forward. And I think that is the motion that must be heard, hopefully by tomorrow. Nnamdi Kanu still remains a prisoner of conscience. He's been detained unlawfully. And we are also using this medium to continually call on Mr. President to invoke Section 174 of the Constitution of the Federal Republic of Nigeria as amended for the Attorney General to enter a nolle prosequi, at least before the determination of the court. We are very optimistic that Mr. President, that we know is a listening and attentive president, and that he will do the right thing in the shortest possible time. Thank you.
My colleague here would like to round up, please.
Okay, thank you very much. Yeah, thank you very much. Well, as an ordinary citizen, as I'm not speaking now as a lawyer, as an ordinary citizen, if I am brought before a court of law, I should know the law that I have contravened.
Yes.
You cannot ask me to enter a defense for a law that does not exist. And particularly the law that the Supreme Court itself has declared non-existent. To what will I be defending? We're in a country where our laws are written. This is not England where you have an unwritten constitution or unwritten law. We have a country where all our laws are in black and white. This is a lawmaker here. They made the law we're talking about. And if you ask him, he will tell you that there is nowhere they made chapter 45 of the criminal code. They didn't make it. The honorable, did people make that law? It is not in existence. So who made that law? Who made that law? Was that law made by the Attorney General's office? And the Attorney General does not have the powers to make laws. So I am saying, as an ordinary citizen, that Mazi Nnamdi Kanu is completely right and within section 36 of the Constitution, which borders on his fundamental right to fair hearing, to be charged with in a court with a law that is in existence, not with a law.
The by Wadalu Lineno, Edikun Venezuela in Rapo, na Eastern News 24. Edika, I call when I get here, no audio, call if 1 night will you why they couldn't get a beef. Oh, yeah, myself, Namalapuno, Kuno Liat, and a comment. If you cheni for Gasi, Dichi, Cheni Rapo, and the kind of check a Yabu court to a Benis in Jerebena Obosinketa. And I call I get you no update after this court session. So make sure you stay tuned to Eastern News 24. Deka Ima no nyendu abatago ononko kipe. Over many reactions na biano. When I say ka ajidegodi eba, I can next kona azo ni ruwa upo. We gunu kaya bi face vega no bosinketa. But kemesi anu munem darun dine.